I always object, even if I agree with the order. I object. Why? Because I literally have in there in my last line, I'm preserving this. I'm not asking. There's no request for relief. This isn't a motion for reconsideration pursuant to Rule 59. This is clearly me preserving my rights for appellate review. That's it. So that, because the way that works, Steve, if you let that order go by and you don't object to it, and then you start litigating more and more and more, you've waived your right for that. By putting that objection saying I'm preserving my rights for appellate review, I didn't waive shit. It's still there. It's preserved if I need to build back off of it. Same thing with those responses in opposition. The way the courts work and pleadings and stuff is if somebody filed a motion, there's a response that you can file. And then after the response is a reply. Those are the only 3 filings you can have. You can add a 4th one if you ask the court for leave, file a motion for leave to file what's called a surreply. So if you file a motion against me, I can respond in opposition to that. Then you can reply in support of your motion saying, no, here's what's going on. And then if you've added new arguments in there in your reply outside of your original motion, then I can I can ask the court. That's what the motion for leave is I'm saying, hey, court, would you please give me the opportunity to address that? Steve's brought up other arguments outside of his original motion. And it'll get, every time, it'll always get approved. But people not knowing that procedural process, they get in there and they just start firing off a bunch of dumb shit. Sovcit, you'll hear crazy things like that, sovereign citizen and that kind of stuff. But yeah, the courts are such a cool place, man. I mean, when you first get in there, it doesn't seem like that. Going to hearings are a little bit intimidating. The hearing I had, dude, I'm telling you, they flew in 2 big boys from 2 big ass places. And that's who I'm taking on for the day. Well, fuck it, dude. If I'm playing golf, I want to play against Tiger Woods. If I'm boxing, I'm going to beat Mike Tyson's ass. I don't want to play around with some clowns. I want those guys. I don't want the flunkies to come in. I want the big boys to come in and start letting their egos fly, because that's there to intimidate me too, as well.
Mm-hmm.
You bring in the fucking 40-year attorney, that's supposed to do something. Well, it doesn't work too well with me, man. It's like, it doesn't work.
I mean, it's so funny because like some of the questions that I had, like you're already answering it. Like if somebody were to get sued, by a debt collector tomorrow, what would you want them to do emotionally before doing anything legally? And that's like the whole,
there you go.
Everything that you're talking about right now is,
dude, yeah.
Don't be emotional about this shit.
Well, first off, you owe the fucking debt, bro. We're not even going to get into that whole, there's a Federal Reserve window and all that fucking shit. You don't have to. That's what I tell, most of the people that will consult with me. Do you owe it? I don't know. Well, I'm not, and in my credit cohorts, same thing. People ask me, should I stop paying my credit card bills and this, that, and the other? And I'll say, I'll never answer that in the affirmative because I don't believe that. I think you paying your bills while you're litigating shows good faith, and it's paid volumes. I have complete evidence to that. I can get a guy named Rudy Nanquil, who's one of my cohort members right now in San Diego, and he's done very well. He's made tons of money right now, and he's already let, I think, 8 of his 10 defendants out. But it's because he kept paying his shit, and he stayed in good standing. That's you. Do you however you want to. You don't have to. There's nothing wrong with that. But, I think that's a good thing you bring up is you really have to sit there and ask, what is the why? This person's coming after you just like you should go after somebody else if they owed you money. What I'm looking for is to detach from the emotional stuff and say, I don't know, or it doesn't matter. You do, and I'm not saying hide from it, this, that, and the other. I'm saying, look at the fucking documents that were filed. Know what it was. So use my Amex case, for instance. They sued me. It's going on right now in Indiana. December 8th of 2021 is when it was filed. So this December will be 5 years. we've been doing battle that whole time. I could have 2.0 version of Joey, if this happened all over again, is I would attack the agreement that they put on the record with an affidavit. Now I filed a counterclaim and did the 1681 stuff, and that's quite honestly probably one part of the reason why it's went on so long was my own doing. But if you look at that agreement, you can open it up tonight. I mean, if anybody's got a myin.gov, you can search Joey Kimbrough, you'll see all my shit, and you should. And if you pull that one up, you'll see all of the filings in there. You'll see everything that's went on. But that agreement clearly says, and I know everybody will appreciate this, and this is my new eyes, this is not my eyes from old, was prior to filing any litigation, either party is to send the other one a notice in 30 days in advance to allow them to cure. Do you think I ever got that notice from Amex? So the very first thing I should have done back then, it would have ended it just like this, was file a 12B6 motion to dismiss for failure to state a claim. They've clearly breached the contract that we have. There's no doubt. So we're not arguing, do I owe the money or not owe the money? And this is what they're notorious for doing, is dragging you down another path, and you start talking about dumb shit that has nothing to do with the claims. Let's talk about the contract that you put on the docket. And it clearly says in the first paragraph that prior to either party doing this, whether it's arbitration, small claims, or litigation, whatever, is to send a notice. And that's 12B6. It's like a 1-page dismissal, and it's done right then and there. But it's back to what I said earlier. If you don't do that, then I can't now come back and say 12B6, failure to state a claim, because I've been litigating all of this time, plenty of other things that I've had. And there's great stuff. I mean, that case in itself has trained me on a lot of the stuff that I'm able to train others on now. So I'm grateful for that. By the way, now I would annihilate a case like that in a New York second, because I would take 3 hours. I would look through everything they filed, and I would snuff them out, within 2 seconds. I see that now in a second, stuff like that, procedural stuff that's going to get it tossed out, just like I just did the UACC one I was referring to. There was plenty. I mean, do you want me to share that and walk you through some?
Yeah, I mean, I'm happy to, like I said, I enjoy the, once we started talking about all this shit and going through, whoa.
Yeah, that's crazy, wasn't it?
That was fucking awesome.
Can you see my screen?
Yes, I can see your screen.
Okay. This is what I was talking about. Anybody in Indiana, any state, start right here. When somebody files something against you, this is Indiana, of course, Indiana Roll of Attorneys, but your state has it as well. This is the attorney. So I look at each one of them. This is the guy that I've now filed a suit against these guys. What's it say right over here?
Ooh, how about that?
So then I do some digging, and I start looking, and again, we have so much stuff with AI that we can go and start finding stuff. Then I find the Supreme Court case where he was suspended because he didn't pay his fees. He didn't do the CLE credits, and there's one other thing he has. But this is a big one too. This doesn't sound very big, but if you read the Indiana administrative rules, it clearly says that they have to have their email, and everything's got to be updated. If you read their appearance, it's going to say in the appearance, let's just go there and look at one. Here's one of my cases right here. This is the one I was just talking about. Let's look at this. We'll look at an appearance here, and that'll be good. So boom, case number, and bang, whammo. Let's look at one of their appearances.
Yeah, and it's even better, people being able to see this shit too.
Dude. Yeah.
Because it just makes everything, it takes the veil away, like you're saying. Like,
here's what their appearance form says here, bro. certifies that all the contact information listed for him or her on the Indiana Supreme Court roll of attorneys is current and accurate as the date of this appearance. And now, so that's huge, and that's where I was just showing you right there. That was the roll of attorneys. So all the information acknowledges that all documents served under 86B may be sent to the attorney at the email address specified by the attorney on the roll of attorneys. You see what I'm getting at? Understands that he or she is solely responsible for keeping his or her roll of attorney's contact information current and accurate. See the Indiana Administrative Discipline Rule 2A. So when you start plugging things like that in and talking to AI and you start showing them stuff like this, has he or she done that? No, that's not there. The role of attorney search tool, blah, 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 specified attorneys are required. It doesn't say you can if you want to, Charlie Gordon. It says you're required to provide your name, your county of residence, and contact information, including what? An email address. Is
amazing.
It here? That right there is enough to get the case dismissed. I hate to say it like that and give somebody false hope, but this is like the stuff that I start looking at as soon as I get into a case, man.
Yeah.
So let me show you the one case I was talking about, and I'll fly through it. So, because I can talk through this one pretty quick. This is some of the stuff that I've got going on. This is the one I just got thrown out. So we'll talk about this one. This is it. This attorney's from Ohio. I don't know what the fuck they do over there other than milk cows in the Amish countryside, but this guy came into Indiana, so he has to deal with me. So now he filed this in camera, meaning he filed it confidential. He shouldn't have done that. In Indiana, we're a free court. So by doing that, I can't click on the links like I was showing you over there. So unfortunately, you're going to have to believe me on this one a little bit. But they filed the foreign judgment. They filed the affidavit of last known address and the notice of mailings and blah, blah, blah. Look at when they filed it. February 17th of last year. I waited until October to come in and pound them. Now, I filed an appearance in here because I don't want to start bitching about the fact that, do you see an appearance on here?
Yeah,
Rule 3.1 3.1 in Indiana says at the time a filing is initiated, you must file an appearance. Fuck it, let's just go over and look at it. I hate the presumptions. What do you know? I like for people to see this stuff and not know this is Joey's version of what it is. I want you guys to just here's the trial rules. This is what I'm always talking about. I love this in Indiana because we have everything in one place. It's like the most beautiful thing. Appearance, Rule 3.1. At the time an action is commenced, the attorney representing the party initiating the proceedings or the party, if not represented by attorney, shall file with the clerk of the court an appearance form setting forth the following information. Shall and must are the two mandatory words that the court has zero discretion on. So if it says, Steve, you shall do this or you must do this, brother, you better do it. If it says you may, you got discretion there. You can. So me being a responding party, this talks about me. If not represented by shall file an appearance form setting forth the information. So that's why I filed an appearance. I don't want to be the same dirtbag that he's being. So when I filed the appearance, then I filed a motion to strike and a motion to dismiss. Say, with all of the things that I talked about before, you didn't file a fucking appearance, first off, 3.1. And I just go through all of those things and I point out what they did wrong. So then they scheduled a hearing. When I had that 41E in here and all that stuff, they scheduled a hearing to discuss that. So then he comes in and files a motion to attend a hearing virtually, and the court granted it. Did you guys not hear me up here say that he didn't have a fucking appearance on the? So if he's not appeared, how in the hell is he okay with attending virtually? You see what I mean? So I'm raising so much smoke now at this particular point. I objected to that order granting his motion to attend the hearing virtually, and I pointed that out. Hey, dumbass, He hasn't even made an appearance and you're allowing it to. So it's one of those things where they ignore you. Defendant have notice issued to parties. Defendant having filed objection to the plaintiff's motion to attend virtually, court sets this matter for the hearing. So they're adding it to the hearing we're going to have on November 4th. So then
they're adding it to the hearing that he never appeared for.
That he hasn't appeared for yet. Yes. and that's the arrogance, bro, that I'm telling you, that he could have said, you know what, Mr. Kimbrough is right. I'm so sorry. No disrespect to the court. Here's my appearance form. And it's over.
But he still hasn't fucking filed it. Still.
Exactly. So then I said, notice of an inaccuracy in the court docket and a motion to correct the error. And that's all because they have this judge, Matt Elkin, was not disbarred, but he was kicked out of the judiciary for the shit that happens in every community. And he's going to be presiding the hearing. Well, as of September 30th, if you look him up in Indiana, and you can, he was removed from the bench by the Supreme Court. How in the fuck is he going to be presiding a hearing when he's not even a judge, bro? So that's what I'm saying. This material inaccuracy needs to be corrected. Do you think the clerk did that? So I'm pointing out the clerk's role in this filing. Hey, you need to fix this. You're saying that this judge that's not a judge anymore is going to be presiding. Please don't do that. So they added that one. They added this material inaccuracy that I'm barking about now. So
they're adding that to the hearing with the judge.
They're adding everything there. So then we have the hearing on this date, bro. And if you could see that hearing, there's a big screen up here. The hillbilly from Ohio's on there, and he's talking shit. There's the judge up here, some old dirtbag. I can't remember his name, Bergstrom or whatever. And he's wanting to do battle with me. And I let it get all the way to his lips of contempt. I love to push him all the way there. Now, Mr. Kimbrough, don't you think the 41E is reserved for the court to clear out the dockets? I said, no, it's not reserved, but it's a tool that you guys can use. It clearly, and we can pull up 41E, Your Honor, if we need to recite that verbatim. That says that if it's not ruled on within 30 days, there has been no, filing within 60 days, whatever it is, then I can move the court. And, he wants to keep talking in those circles. And then I'm cracking this fucker that's on the TV. I'm saying this fucking clown hasn't even filed an appearance, Your Honor. What are we even doing talking here? And I'll get all the way there. Mr. Kimbrough, we're not going to do that. Are you done? Yeah, I'm done, Your Honor. Carry on. And meanwhile, there's the black dude with the big ass gun hanging off his side sitting over here. All of this is to intimidate you. And again, I'm respectful, but I'm only going to be as respectful as you allow me to be. Look what he did on the same day. He fucking filed an appearance because I raised so much hell in the court, made him look so fucking stupid. All of this stuff he had done before, bro, was for naught. Now he can start doing stuff because he filed an appearance.
So he filed the appearance after the
hearing, literally on the same day. Yeah, he's milking cows and he says, you know what, Betsy, I better fucking go in and file an appearance. Joey's raised a lot of hell. But in that hearing right here, the judge said, and this is why it's important to pull transcripts too, if you don't have a memory. He said, and it wasn't Matt Elkins either, by the way. It was that Michael Bergstrom or whatever his name is. He said, guys, I'm going to have you an order by the end of the week. This is November 4th, bro. Mm-hmm. End of the week is like November 7th or something like that. Nothing happens. He files his appearance. He talks about the hearing journal. This is the clerk, by the way. I let 1 month to the day go by, and then I filed a Rule 53-1E. If you read that rule, it talks about removing the case to the Supreme Court to get another judge. You told me by the end of the week, you're going to have a ruling, which should have been in my favor, and you didn't do shit. This is the part where people in Indiana, anywhere, not Indiana, anywhere, they don't know that they're the ones driving the case, bro. If you don't know these rules, the Rule 53-1E, read that, and it tells you how to remove the case from this fucking clown. So then, here's what always happens is 1 month to the day, I have the right now to remove it. As soon as I did that, the case is no longer jurisdictionally in Howard County anymore. It's with the Supreme Court in Indianapolis. But as happens in 9 out of 9 fucking cases, Nothing happens. That praecipe is a writ. A writ is a command. I'm commanding the clerk to withdraw this. If you read that rule, you'll see that's exactly what's happening. The clerk is to send to the CHOW, Chief Administrative Officer, the docket and my praecipe. And because it clearly spells out what's not been ruled on. You held a hearing, you had 30 days to rule, you didn't do it, it's time to remove from your court. 6 weeks later, after the clerk doesn't move, and the clerks don't move, they'll fucking ignore you. And that's what people get pissed off about. Why isn't anything happening? Why aren't they doing anything? Because you're not driving. I know that I'm the driver. Give me the fucking keys. And if you're not going to do what I say to do, then I'm going to compel the court to do it for you, clerk. So then I filed a motion to compel the clerk to forward the praecipe. And boom, he signed it right away, Michael Berkson, because he knows he's fucked, right? He signed it the very next day. I'll show you what that looks like. This was my order, by the way. I created this order to compel. All he has to do is sign it. So I put all of the information in that I wanted, and boom, he signed it. When you have that dopamine hit, when you create something, I created this order. A lot of people see this and they think, well, the judge will sit down and create. No, dude, they're too fucking lazy. It's called a proposed order. When you file anything substantive, most times, if it's dispositive, especially, you're supposed to file a proposed order. The rules clearly tell you that. But anyway, I created this. He now says, you know what? You're right. Send it to the Supreme Court. He had to. He had no other choice. So, but that's just, I want to be clear here what's going on. I gave the command to the clerk that, you know what, time is told. It's time to go, bro. We're going to the Supreme Court. And they ignored, like they will you. 6 weeks later, I got tired of it and said, you know what, fuck you. We're going to compel and he did. The judge, he has no other choice. Right. So now you've got the clerk filing an affidavit. Yes, I send it down. Here's what I'm doing, and if you read through a lot of these, I send these a lot, by the way, they'll start throwing each other the bus. The clerk will say, well, we didn't know we were supposed to do this and blah, blah, blah. Come on. That's so now the Supreme Court said that they received it. Order received from, and this is April, by the way. So there's nothing that happens quick in the courts. January is when so February, March, April. Where 3 months later, the Supreme Court sent an order. Well, let's see what they said. I already know what they said. The CHOW, pursuant to Indiana Rule 553.1. Oh my God. Fuck, we're talking about rules now that I actually know about. That's right. The thing that most people think at the trial level is like fucking college algebra. It's a weed out class. The trial court is nothing more than fucking weeding you out if you don't know what's going on, because they'll try it 9 days from. These guys are the ones that actually created the fucking rules. They've got to be looking down at all of us dumbasses and thinking, bro, we've got the rules there for you. What are you doing? You're going to let them fucking do this stuff? This is a perfect example of we don't let them do shit. Review of the CCS. The filing notice of foreign judgment with the court in this, blah, blah, blah. They're just talking about on December 4th, Joey Kimbrough filed a praecipe with the court. In the praecipe, petitioner accused the court of failing to timely rule on the November 1st inaccuracy. I didn't care about that one. CCS reveals the petitioner's November 1st motion was taken under advisement on the 3rd. Requires a court to rule on a motion not later than 30 days after its filing date. So remember, he tricked me into thinking it was going to be the end of the week, and then he sat on it for fucking a month. Required not later than 30 days. I waited, and 30th day I dropped one in him. The CCS does not reflect the issuance of a court order concerning the petitioner's November 1st motion within 30 days. Mandated by rule. The court's failure to timely rule on or before December 1st constitute a per se violation of 53.1a. The praecipe is granted. That's my first ruling from the Supreme Court of Indiana where they took me serious, bro.
Hell yeah.
I'm tearing up right now. It's like when you get something like this, it starts becoming real. It's like, look, I can drive these things. And I'm the one that controls the fucking court, or I let them control it for me. So then they come in here. Now it's my girl, Loretta Rush. She is the Supreme Justice in the Supreme Court. Why isn't this opening? Okay, here it is. There's another one coming from the Supreme Court. Loretta Rush, Chief Justice of Indiana. She's talking about Honorable Michael Bergstrom is directed to file a report with the Indiana Supreme Court 531F. That's why they don't want this to ever happen, bro. Because it's a huge issue for them. They got to start filing reports with the Supreme Court on why they were a dumbass and didn't rule on things and all this other bullshit. And then they have to provide it to the next judge coming in. And it's like, actually, they have to work now. Judge Bergstrom is directed to vacate any orders issued in this case after the filing of the praise of pay and to cease exercising jurisdiction. You're kicked the fuck out, dude, over the case except to do any administrative tax. So go fuck yourself. It's therefore further ordered that Honorable Joshua P. McMahon, which that's funny because he's an attorney, but he's also a Howard County prosecutor. I know Josh. I've sat with him. He does a lot of the trust work for my mother-in-law and aunts and all this other shit. So I already knew he wasn't going to take jurisdiction because he knows me, and I'm glad he wouldn't do that. If he put himself in that position and then UACC found out we had a relationship, look, literally the next day, judge recuses jurisdiction. I knew he would. It's like, no, I know, bro. You know,
conflict of
interest. Come to
Howard
County and probably not know me in some way. So, and here's the key where it starts getting really good for anybody that's thinking that they can't do this. You can. The special judge assumes jurisdiction. Steve Kitts, I've been in front of him before too. He's up in Logansport, just up the street from me. He comes in and he starts saying things like counsel is directed to call Dana Kelly to schedule hearings with special judge Kitts or email her, blah, 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 blah. He's setting himself up to want to start presiding over this case. I stepped right in, bro. I stepped right the fuck in and filed a defendant's motion to renew and bring forward all outstanding unresolved motions before the court. Now, we don't need to talk about shit. I ain't scheduling nothing. We just need to talk about the motions that numbnuts didn't want to rule on. Mm. So when you see that, I filed that on May 12th, May 19th. Here's the order. Keep in mind, I'm the one that created this order and sent it with that motion. So it was attached to it. But dude, talk about high number 2. So I've got the Supreme Court and I've got this order that I created. If it ever opens.
For whatever reason, that when our little box is over that, it doesn't look like it wants to.
Yeah, it's bullshit. Here we go. So I created this order, this order on the outstanding stuff, and I went ahead and wrote all of this up, gave him everything he needs here, and then I said, plaintiff's notice of filing a foreign judgment hereby is stricken because it should have been. They didn't file an appearance. And it was defective. The cause is hereby dismissed without prejudice. Most people would say, Uncle Joey, why wouldn't you have dismissed this with prejudice so that they couldn't have brought the claims back? Secretly, I'm wanting them to come back in. Let's do it again, bro. Let's dance. I'm not saying that arrogantly. I'm saying that I want you to have the opportunity to crack me if you think you can in my state or any state. The court's order dated October 24th, granting plaintiff's counsel virtual appearance is hereby vacated. Boom. I just got him wiped off the face of the earth. It's like he was never here. He never appeared there because it was vacated. All proceeding, here's the important thing, that if you guys ever create anything, you should always put this in here too. All proceedings of enforcement actions related to the foreign judgment filed in this cause are stayed, meaning they're put on pause, and unless and until the plaintiff complies fully with Indiana Code 345411, Indiana Trial 331, and all applicable procedures. This means that if they think I owe them something, they can't start that whole fucking collection process and calling you and running you fucking nuts. So I got a court order dismissing their horseshit. But I also got a court order that's staying any kind of collection actions that you think you're going to do against me. You can come sue me again, but you're not going to try to collect on it until you sue me. So
Nice.
it's like, the clerk of the court shall enter this in the CCS. All of the requests is granted, signed. And you talking, dude, hi, man. So I used,
how much of that document, like you said, you wrote that order, but to what effect? Like the entirety, to include like where his signature is and everything, or
Mhm.
so
I wrote
like here's the
everything
signature
except his
line, you
signature.
put it, huh?
I wrote everything except his signature.
Gotcha.
So if you look at the document I created, it'll literally look exactly like that, word for word, except his signature. It'll have a
Gotcha.
blank signature line there with nothing on it. He just came in and stamped his signature and dated it, and boom, it's done. So I literally created every word. But here's the other thing. I sent this to UACC just so they know. I like them to have. I sent it certified, signature required, the whole bit. But this is not arrogance. This is me just letting them know. Don't fuck around. Please don't do this again. Final and conclusive notice. Court order entered May 19th. No further correspondence will be issued. And I just went through the whole history and just gave him a little slap on the ass and says, don't try this again. This is the last time there's no stay. There's a stay of enforcement. And I'm reserving all my rights. This is my final correspondence to you. Have a good life. And then I attached the actual order that you just saw that was signed by the judge. So they can't say they didn't know about it. You know what I mean? I sent them everything here. They signed for it. I'm crazy about letter stream and collecting evidence and all of that stuff. It's right here. Boom. Let's open it up. Let's view the signature. So some guy named Brad Church signed for it. I sent it to their registered agent that's in Indianapolis, CT Corp. But Brad Church signed for it at June 1st at 10:21 a.m. in Indianapolis. And then it's his responsibility as registered agent to forward it to them. As soon as he's served, they're served. So that's me getting a case dismissed as a defendant in Kokomo, Indiana, man. Howard County.
Fucking 9 months.
9 months. Actually, it went longer than that because they had another one on there.
Oh, yeah. Never mind. That was February 2025.
Yeah, they filed it January, and then they dismissed it themselves after talking to the clerk. I have a FOIA or an INAPRA, it's called in Indiana Access to Public Records with our court. And it's so funny, dude. I sent that and I just wanted to know the communications that went on here because it literally plaintiff's counsel contacted the clerk's office. Clause was filed as a CB instead of an MI. Staff contacted plaintiff's counsel regarding now the clerk is actually fucking what are they doing?
Yeah.
What is all this ex parte communication going on amongst each other? So I'm asking these questions with the clerk, and the clerk, it's so funny, bro. When I sent that, I sent that with to Howard County as well. So I use LetterStream for all my shit. It's just a lazy way to send certified mail for signature from your computer keyboard. So INAPRA request to Howard County. That's this right here. So they responded, which is crazy. They didn't sign for it or anything, but they responded back to me and says, "Hey, this is just confirmation that we received your shit." The clerk did.
Funny. Isn't that annoying though? Because when you pay for the fucking certified with a return fucking receipt and signature, and then you don't get that.
Yeah. Well, I got it whenever they responded to me that said they had received it, which I appreciate, by the way. They're supposed to respond within 10 days. And the funny thing about that is, dude, is it was let's just call her a deputy clerk, said, "Hey, we've received your stuff and we'll get to working on it." Well, Debbie Stewart, the fucking fat bitch that's our clerk here in Howard County, jumps in and says, "Hey, before you send anything, let me send this to Alan." She's copying me on it. She didn't realize she's copying me on it. Joey's one of our pains in the ass, essentially. So I copied Alan Wilson. Wilson's our Howard County attorney. And I said, Miss Stewart, can you please let me know what you mean by Joey is one of our pains in the ass? I truly want to know that. I'm being respectful as hell.
Right.
Can you please fill me in on what it is? They've never responded yet. So now probably tomorrow I'm going to send them another and say, look, this isn't out for debate. I'm not asking anymore. You're going to give me the public records that I'm asking for. If not, we'll deal with that. There we go.
Dude. And that's the shit right there. Like, just for people to see that shit and how it's nothing like, and I think we were talking about this once before, when people watch TV shows and movies and they see these fucking attorneys, because I remember bringing up the phrase crossing your fucking T's and dotting your I's.
Mm-hmm.
And you're like, well, that comes from litigation, right? I was like, no, I didn't actually. But nobody fucking does it because they don't have to. Nope. Because like you said, it's their own club and people feel like they're going to get railroaded because they will if they don't. And so, that mentality, unfortunately, is true if you let it be. But as you've just shown, all it takes is to fucking stand up for yourself.
Yeah. It's actually really easy, dude. but there's so much intimidation there. I get it. I truly do get it. Because I was there too. And I'm not trying to portray myself as Barney Badass. And you know what? I'm a semi-intelligent dude. If I can do it, anybody that's watching this can do it. I promise you that. But don't go into it half-assed. If you do and here's the thing, you saw how long it took me to get it dismissed. Mm-hmm. Things do not move at lightning speed. They filed in February. It was October, 8 months later before I filed in and started doing work. So in that 8 months, dude, you could know everything with an AI agent about the courts and the rules and all this stuff that I'm talking about.
Right.
You build an agent, you upload each of those 4 sets of rules in there and you just start studying. Now you're going to do very well in that because that attorney is going to say exactly what, Your Honor. He's all he has to do, Steve, is prove excusable neglect. Because the question is naturally there. Why'd you let this fucking thing sit on the dude for 244 days? Mm-hmm. 8 months. Why? That's just, huh? So, now that Mr. Kimbrough's moved this, you didn't file anything in 60 days. So 41E is very real to get this failure to prosecute's what that rule is. Well, Your Honor, it was at the back office and that's what they'll do, dude. In my Amex case, there's an attorney that filed in and started talking about his cat's fucking died. God love him. It's nothing I'm making fun of, but I know why he did it. He did it just to get the excusable neglect box filled. So this attorney from Ohio did the same thing. Well, our back office grabbed it. Yeah, we do plan on, prosecuting the claims and this, that, and the other. Well, why didn't you file an appearance? That's what I'm interested in. Well, you really don't have any answer there, bro.
And there wasn't even I don't recall seeing it like a summons to you either.
No, typically you would if it's like a tort case, that one there where you're perfecting you're right, by the way. That's another one. That's great you said that. That's cool because you should have a summons and the complaint. There wasn't a complaint in this regard because they already got me. In Orange County, California, I owe $22,000. Well, good luck. I'm getting ready to go there in 2 weeks, by the way. I don't care. So they got a judgment against me there. They tried to bring in Indiana. So there really wasn't a complaint. But I agree. That's an argument that you can make, and probably rightfully so, that where was my summons telling me I had 21 days to answer this complaint or whatever it is. All they're doing is they're not litigating it anymore. The litigation's done. I owe the $22,000 according to the court in California. But they're trying to bring that over here as like a sister clause, kind of a thing, and perfect it over here. Enforcement's what it's called over here in Indiana. And I just shut them down. Good luck. Good try. I tried to file in, and this would be my next thing. If they came back, and secretly I'm hoping they do, And they tried to go down this path again, and they did everything right. And they're not stupid from a procedural standpoint, which God love them. I would argue from an Indiana perspective, I filed into the California case. California's not like Indiana. California's a pay by play, So I had to pay them $870 because of two defendants, JMC Auto Works and Joey Kimbrough. That was my dealership and me. So $870 I sent them with the filing. There was something on the filing they didn't like, so they kicked it back, plus my $870 back. I have all that proof. I tried to defend myself in California, but they kept me from that, even if they would have. Indiana is Article 1, Section 10, I think it is, in our Constitution clearly says that any person that's had harm done to them, the courts are open and free access, without paying. And I know I'm fucking that up. I'm trying to paraphrase it, but essentially we're not a pay for play state. You saw it going into mycase.in. I didn't pay anything for any of those filings there. I just came in and clicked on just now to show you guys. You do that in California, you're paying per page. You do that on Paster in federal court system, you're paying 10 cents a page. In California, it's like $1 a page. So if they would have came here and perfected that lien, that's the first thing I would have said. It's against Indiana's policy. It's public policy, whatever the fuck I would wordsmith it and I'd get it right. But I would essentially argue that point. The judgment that you got there does not match the judgment that you would have to get here. I don't pay for things here in our court systems. So it would be completely against what our Constitution says. For me to have to pay $870, you kicked it back to me, goes against the very Constitution Indiana has in place. So if they came here, they would have to relitigate the entire thing, which that's kind of what I'm wanting to have happen. I don't think they will. They've already paid $5,000 or so, probably retainer to that dumbass that came in, fucked everything up for them to try to collect something that they're not going to collect it anyway. That's just the reality of it.
Yeah.
Because I don't owe it. It was one of the cars that I'd sold that my dealer agreement says that you had to pay the first 2 payments, I think it was. And if you didn't, then it fell back on me, the dealership agreement that we had in place. That was horseshit too. I'd talked way back then, years ago, talked to the husband and wife, and they said, yeah, we made the first 8 payments. We didn't have any problem. Here's everything we have. So anyway, they stopped paying at some point and car got repoed, whatever happened there. But then of course they're going to come back to the dealer and, try to come after me. So, anyway, those are just some I've got a lot of those kind of cases, but really that's not my sweet spot is in the credit game, man. That's where I'm solid,
Yeah.
That's where the 15 USC 1681, that's what I teach. That's what I breathe. That's what I live. My credit score is where it's at. I made a lot of money off of my credit and business credit. In my first cohort that I put together, I went in and tested this because I had a kid in there that was good with business credit. And he said, here's the things you do, Joey, blah, blah, blah. And I said, well, fuck mouth. Let's just test this out. You got a guy that's sitting here saying he's above 800 and all this stuff. That's me. So watch me go. So I went to PNC. I went to Bank of America and I went to JP Morgan Chase in Carmel. PNC was here in Kokomo. The other 2 were down there. So I went to PNC. I brought in, an LLC from the state of Indiana that was in good standing, GF Enterprises, and my credit score, and that was it. I walked in, literally talked to Nikki, the branch manager, said, hey, I'd like to open up a business account. Great, come on in. And that's the only thing I had. Some people have that misconception that you need W-2s, you need tax returns and all this stuff. That's not true. I can debunk that. I walked in there, her and I filled out the application. She jumps in and she looks on the Secretary of State. She sees it's in good standing. Joey Kimbrough's the managing member. Yes, this. pulls my stuff up, sees, oh my God, he's an 833 at that particular point. Fuck. So, well, what do you want to do? Well, I'm just wanting to open up a business account. That's all I want to do. Okay, well, we're going to do this. How much you want to put in? I don't know. How much do I need to put in? She said, well, we're going to open you up 2 checking accounts. So I gave her $500 for one, 500 for the other. She said, we're going to do this one for your operations and this one to pay taxes out of. Okay, Nikki, whatever. You're the boss. So I leave there that night. She said, I got to tie up some loose ends, blah, blah. 22 hours later, she texts me and says, oh, by the way, your credit cards got approved for $20K each. I literally have them sitting over in the drawer right here. I bring them out all the time. $40,000, 20 for each one of those I got without no W-2s, no tax returns. And I said, nah, man, this can't be true. Cause that's not, remember you and I talking about programming. We've been programmed that you need business credit. You got to have all these things. And I didn't have, this is freaking me out right now, bro, because some fucking 35-year-old kid named Maleko that's a Greek guy that's a server in fucking Austin, Texas, that happened to come to an event I was speaking at that now is in my cohorts telling me this, and he's just blown my fucking mind. So I got on to Bank America. It's the same fucking thing. I want to open up. Some little Indian chick comes out. I go in the back with her. We fill out a business application. She runs my shit. She does blah, blah, blah. $500 I gave her. I didn't apply for any credit there. I haven't yet. I still get shit from Bank of America all the time, but that's ripe. It's there. I can. And I go 2 doors down to JP Morgan, and that's the big gorilla that everybody wants to wrestle. I go to a gal, and the gal takes me back immediately and gives me her boss, and they start talking in a different language meaning money, talking about, so here's what they wanted. They wanted my Stripe reconciliation because we're talking at a different level again. And we're talking about me having a regional platinum business manager that's going to be following me around, and they only do this for exclusive clientele at the million and above, net worth, blah, 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 blah. So, okay, what's that mean? Well, if you put 100,000 on tap with us, it gives you all of those things and these things. I don't mind putting 100K on tap with JP Morgan, but it was kind of like the simplicity of the PNC. This is simple too, but it's like, feels like Elon kind of thing. So I didn't put 100K on it. I put like 10K in there, and let's keep the conversation going. So I left at Carmel, came back home. Then they tapped me into a conversation with their merchant services. They're wanting to get in bed with me fully. We're not just kissing and hugging anymore. They want to jump all the way in. So it's like, well, what does this mean? Well, their merchant services gal from South Dakota or whatever, and the big boss down in Carmel and me were on a Zoom call, and they're talking about giving me a $1.2 million line because they just looked at my Stripe reconciliation, and the month before I'd made 115K, doing this kind of stuff. And they said, okay, cool, we'll bring it. And I'm thinking, as this is going on, I don't want to show them anything in my back office. Not that I'm trying to defraud them in any way. I just don't want JP Morgan seeing my URL that goes to a place that says Pro Se Joe, that says I teach people how to sue fucking banks and lawyers and shit. Right. That wouldn't be a really good start to a relationship with a bank, right? Especially the biggest one in the world. So I'm like, no, guys, I appreciate it. And I'm just going to stay here with what I've got now. I really like Stripe. And then they're trying to really go on the sales pitch about how they can save me money. And no, I like simplicity. Stripe's really cool. And that doesn't mean we won't at some point. So that just the phone calls kept coming. And then I did apply one weekend for a business credit card and a personal one. And the business card, I was immediately approved for $35K. And the personal one was $14K. So here's another 50, so literally 20, 50. And I haven't even done anything with Bank of America. So it's like, if I started running Facebook ads and started talking about what I'm passionate about doing and saying, hey, here's some of the results. You could really, and this is fun when I have a friend like Sonny that I can call, who's a retired police officer. When we start talking, he's like, look, are you going to pay JP Morgan back? Because a lot of people will go there, right? If when Brandon's standing up at an event and saying Joey's found infinite money, there are 4,000 banks, and if you can clear your profile and then go to the next bank and get a line of credit and fuck that up, and then you clear your profile and go to the next one. 4,000 banks you and I could never go through. And then you got to be careful with the wrong audience hearing that and knowing the power in that. So when Sonny asked me that question, it's like, I know he's asking me from a police officer's standpoint, and he's wanting, and the answer is immediate, fuck yes. Because next month I'm going to go ask him for 200, and then I'm going to pay him back again. And then I'm going to ask him for 400. But here's the key is if and when that relationship has to end because people think I'm nuts and don't want to support the, whatever it is, and stuff goes awry. This is Elon, Donnie, any of those guys that have been billionaires that have filed. I'll burn that bridge in a New York second and move on to the next one. Instead of saying, oh, woe is me, it didn't work out, I'm stupid, and I'm just going to, all of that stuff. No, just if I hop in my lane and I do really well and I have a credit line established, I'm going to do everything in my power to pay that credit line always. But the moment that it doesn't work, I'm going to burn it down and pivot and move, man. And I'm not saying that. I don't want anybody to take that wrong. I'm not now there are people that's going to go out and get 100K and then blow through it on fucking hookers and boats and hoes, and blow and whatever they do and be stupid with it. Somebody that's 56 living in North Central Indiana, I'm wanting to make an impact in this world. I'm not interested in goofy anymore, so that's it. I mean, that's what I have fun doing. And yeah, man.
Yeah, dude, it's like I said, it's so interesting because it's something that, I mean, even when you get into conversations with people that are not, a normal conversation, that are outside of, hey, how's the weather? How's your fucking family shit? You go into a little bit of a fucking deep, even like I said, talking about, you can talk to a lot of different people about fucking mindset stuff, about, meditation, the stuff that I talk about and help people with. There's a lot of that out there. This is something that is so, from my perspective, at least, I haven't seen, a lot of people that talk about and do and deal with this fucking world. And that's what makes it so fascinating. And I think, like I said before, to bring it up for people to really think about it, as you're saying, is it an infinite money loop? I mean, it could be. Should you use it that way? How moral are you? Right. We have our integrity. Like, you don't want to be playing that fucking game all the time, because otherwise it does bring up, because even still, like, we talk about the mental aspect of it. You can have a lot of mental fortitude and resilience, emotional resilience, but if you're doing this constantly, it's going to fucking take a toll on you, So, and with that, like, how, for you personally over the years, like, how has that kind of really changed your mindset or your emotional state through, learning this whole process? Like, obviously, when you were talking about the case that just got dismissed in April or whatever it was, and seeing the signed document from the Supreme Court, like, validating you, like, that's a fucking, like you said, that blows you up so much.
Yeah.
Right. But even still, like, it's a lot of energy, like, to put into this stuff.
It can be a draw too, bro. I mean, you're going against energies that are not matched with yours. So to your first point, how many people are doing this? I haven't seen any. I'm with you on that, bro. I never have seen anybody talking about it outside of maybe myself and a couple others. So when I started, when I'm sitting in there in my bedroom, laying up against the wall after I was served with a knock at the door at December 8th, 2021, it's either, dude, you're going to have to be in that statistic with everybody else, or you're going to have to learn this shit, bro. And I knew who was tapping me in, if you know what I mean. So I was good with learning it. and it's been very lucrative for me. I'll say that. But there was nobody talking about it. I did like most people. I went to YouTube and I tried to find it. And there's some people telling you to do stupid shit, file these letters, do this. The judge doesn't have jurisdiction because he's a clown, whatever. There's all that stupidity that's out there. But there was nobody doing what I'm doing. And this is how I teach it to my cohorts. I'm not holding on to anything proprietary. I teach 54 videos my cohorts created off of. I've created a fictitious avatar named Raina Cardwell, who's a nurse with 2 kids in Indianapolis, Indiana. She's fictitious as fuck. And I did that because I didn't want anybody bitching and saying, well, you're doing it. So I said, fuck it. I'm just going to create what I've created in my Snap-on case for this fictitious avatar named Raina. And you guys get to follow along. And if you do the same shit that I'm doing for her, you're going to be successful because it's built off what I know. And that's the only way I know how to do it. And when I do that, I teach that from, look, this is a blue ocean. It's a bluest fucking ocean that there is out there. There's nobody talking about this. But if you'll hear me, and I know you did at the beginning, I did it for me and I was successful. And then I did it for my buddy Tim and I was successful. And then I started taking clients on at $5K a rack, at $5K a pop. And that was like fucking, I felt like an Egyptian slave because of all the work that has to go into this. And then I built that up to $30K. And I could still be doing that to this day, maybe even going north of that. $30K, I'll build out all your shit for you. And when you get in the court, I'll consult with you and tell you what to say and how to say it, and you're going to be fine. And that was fine. But that was still that time draw. So how can I do this to where I'm not, building this out 10 times, 12 times a year at $30K a pop? And if I raise it more, there's all these things going on in your mind. So how about I just build this out how I did it? People can learn. And then if you want to go out and do it yourself, please do. I'll show you how the back office works. I'll show you what my Stripe account looks like. I'll show you all that stuff. Mm-hmm. And you can go out and do it yourself. Now I've had people come to me, and now it's like, I just had one from Fort Lauderdale reached out, and got on the Zoom calls, and I said, hey bro, Matt, it's going to be $50K, bro. And he was one of those Bitcoin millionaires once upon a time. His mind's still there, but now he's looking at his account and it's like, oh, I don't know, I can't do 50, So, I sent him to Sonny, full disclosure. I said, look, I got a student I think highly of. I'll talk to him. And if he's cool, you guys work things out. I'll do the warm introduction. I'll step back. And I did. And Sonny pitched Sonny 10K because that's what he told me. Once upon a time, I'd have jumped on 10K. It's not for my time now. It's like, no, fuck you. 50, I'm still like, dude, because I know the work that goes into this.
Right.
So he and Sonny talked, and I don't think where things worked out, but regardless, if I have people come across that I'm not interested in, fuck yeah, I'm going to send them to the people that have been walking with me that I feel confident know what it is I'm saying.